Welcome to part 2 of my two-part video, where we will continue our analysis. Let me remind you that I surrendered my law license when I retired and closed my practice. Therefore, nothing contained in this video constitutes legal advice. It is for education and entertainment purposes only. I am only going to give you the facts, as I understand them. I will include case names, so that you can Google them, if you'd like, and you can read them for yourself, so that you can make your own decisions. With all that said, I'm putting my law professor's hat back on now. So, let's begin where we left off. In the last video, I showed you what the Constitution, laws, and case law have to say. It was shown that you have an absolute right to move about the country freely, and to travel to wherever you like. I also showed you that those rights can be controlled by the authorities, by the imposition of the requirement that you be licensed. As long as the laws and requirements are equitable and are uniformly applied to all persons, they've been upheld. We all learned in our 9th grade civics class that rights can be limited. Just because you have a right does not mean that right is not subject to governmental limitations. For example, I'm sure you've heard it said before that you have a right to free speech, but you can't yell fire in a crowded theater. You have the right to consume alcoholic beverages, but you can't drive intoxicated or even be drunk in public. Courts have long said that because there are inherent dangers in operating a vehicle poorly or without adequate training that could cause harm to others, it is in everyone's best interest to make sure that the people with whom you share the road know what they are doing and are properly licensed. In the case of Hoffman v. Potomac Edison Company, the Maryland Supreme Court in 1934 held, transportation is usually held to be lawful and reasonable, so long as it does not interfere with or endanger others, lawfully and reasonably engaged in the use of the right-of-way. In one of the first right-to-travel cases, involving motor vehicles, the Supreme Court in 1927 ruled in Hess v. Pawlowski that states could put reasonable restrictions on motor vehicles using state highways. Other Supreme Court decisions have also restricted the rights of individuals with regards to motor vehicles. For example, in 1915, in the case of Hendrick v. Maryland, the court upheld the registration requirement of motor vehicles as a reasonable use of the police power. It noted that, quote, the movement of motor vehicles over the highways is attended by constant and serious dangers to the public, and is also abnormally destructive to the ways themselves, end quote. In King v. New Rochelle Municipal Housing Authority, the Second Circuit Court of Appeals recognized the right to intra-state travel. The court reasoned that, quote, it would be meaningless to describe the right to travel between states as a fundamental precept of personal liberty, and not to acknowledge an equal constitutional right to travel within a state, end quote. In Shanks v. Forsyth County Park Authority, the court specifically rejected protection of a particular mode of travel. The Shanks court reviewed the constitutionality of a statute which banned motorcycles from a park. Even while assuming that the right to intra-state travel existed, the court found that the ban did not affect a travel right because it only regulated a particular method of travel. The court reasoned that, quote, people are free to travel inside the park through other methods of travel such as by foot, car, bicycle, etc. As such, the ban on motorcycles does not impede a person's right to travel but merely regulates the method of travel once inside the park, end quote. Other courts have uniformly rejected an implied right to choose a transportation mode in right-to-travel cases, and most cite to the case of Miller v. Reed. In Miller, the 9th Circuit Court of Appeals held that the plaintiff did not have a fundamental right to drive an automobile. Further, it held that a state could constitutionally revoke a driver's license. The court also noted that they had previously held that the plaintiff's preference for an automobile does not infringe on their right to interstate travel, as plenty of other options were available to the plaintiff. The plaintiff is not being prevented from traveling interstate. There is also the option of public transportation, common carrier, or even in a motor vehicle driven by someone with a license to drive it. Some of the major cases that cite Miller include Dukin v. Cohn, finding that there is no fundamental right to drive a car. Avery v. Perseberg, holding that restrictions on a single mode of transportation do not rise to the level of a violation of the fundamental right to interstate travel. Tudor v. City of Haley, holding there is not even a right to travel by private jet even if you can afford it. My personal favorite case is Berberian v. Petty, which is still good law. I will recite the quote in its entirety, because of the sheer significance of what they said. But be forewarned, it is a lengthy quote. The court ruled, quote, "It is equally clear that the right to operate a motor vehicle is not a fundamental right. The importance of that right to the individual, in modern society, does not determine whether it is to be regarded as fundamental, for the purpose of review under the Equal Protection Clause. For equal protection purposes, only rights explicitly or implicitly guaranteed by the federal Constitution are fundamental. The right to operate a motor vehicle is wholly a creation of state law. It certainly is not explicitly guaranteed by the Constitution, and nothing in that document, or in our state constitution has even the slightest appearance of an implicit guarantee of that right. The plaintiff's argument that the right to operate a motor vehicle is fundamental because of its relation to the fundamental right of interstate travel is utterly frivolous. The plaintiff is not being prevented from traveling interstate by public transportation, by common carrier, or in a motor vehicle driven by someone with a license to drive it. What is at issue here is not his right to travel interstate, but his right to operate a motor vehicle on the public highways, and we have no hesitation in holding that this is not a fundamental right." End quote. I am not sure that I could have explained it any better myself, which is why I chose to quote it in its entirety. Please feel free to look it up yourself. The site is Berberian v. Petty, 374 A. 2nd. 791, Rhode Island, 1977. Finally, in Minar Travel Services v. Associated Cultural Clubs, the court used a very creative way to describe what the law is. The court said, quote, "A rich man can choose to drive a limousine. A poor man may have to walk. The poor man's lack of choice in his mode of travel may be unfortunate, but it is not unconstitutional." End quote. So, to summarize this video, the courts have guarded the right to move freely, both within a state and from state to state. Your right to travel is fundamental. They have guarded this right zealously, and it is without question. But what they have not protected is a person's ability to choose their method of transportation. Therefore, courts have clearly stated that there is no fundamental right to travel as the driver of a personal vehicle. Do you agree? At this point in my lecture, we would be having a lively class discussion, but since that is not possible, please leave your comments down below. Thank you for watching part 2. Please don't forget to like, subscribe and hit the notification bell, so you don't miss any new content. If you don't, you'll make my dog sad.